In Scotland, each court has its own set of procedural rules, and each type of action has its own particular rules too. We do not have the equivalent of the White Book in England and Wales, but instead we have annotated rules for the Sheriff Court and the Court of Session, and these are divided into chapters covering each type of action. It's beyond the scope of our webinar series to look in detail at all the different sets of procedural rules, but instead we'll focus here on the general procedure in the Commercial Court of the Court of Session, which is where we most commonly represent clients in respect of some of the most complex and high-value disputes. Now, prior to raising a commercial action, it is expected that parties, where possible, will exchange correspondence setting out the respective positions and providing each other with any documents they seek to rely on. If the claim is one where an expert report will be required to be relied upon, then it too should be intimated during the pre-action correspondence. This guidance is embodied in a practice note issued by the court, albeit it is not a compulsory type of pre-action protocol that is common in England and Wales. Nonetheless, the court can take account of any failure to comply with this direction when considering an award of expenses in the case. Indeed, there is only one type of compulsory pre-action protocol in Scottish procedure, and that is in relation to personal injury actions worth up to £25,000. Beyond that, there is only voluntary pre-action protocol, including in respect of disease claims and professional negligence claims worth up to £20,000. Thereafter, in terms of kicking off an action, proceedings are commenced usually by way of a summons, although sometimes by way of a petition. A summons is used where a pursuer is seeking to establish and enforce a right against a defender, whereas a petition is used when the authority of the court is required to do something.
A summons runs in the name of the sovereign, and when you hear us talking about signating the summons, that is the process whereby the document has the royal seal or signet applied to it. The signet means that the pursuer has the authority of the court to proceed with service of the action on the defenders. A case is not independent until it's been served, and therefore service on the defender is necessary to stop the prescriptive clock from running. Up until very recently, there was no such thing as standstill agreements in Scotland, but a form of standstill agreement has just been introduced in the Prescription Scotland Act 2018, which received royal assent on the 18th of December 2018. At the date of filming this webinar, the Act isn't yet in force, so please do keep an eye on our website for updates. In any event, the type of standstill agreements which are coming into force in Scotland are not quite the same as those you will come across in England and Wales. The important point to keep in mind is that signating is not enough, and service of the defender is also needed to stop the prescriptive clock. There are also time limits on serving the summons on the defender. A summons needs to be served within a year and a day of signating, unless it's a personal injury action, in which case it must be served within 3 months and a day of signating. If it's not served in the year and a day, then the instance falls, which means that the authority of the court is lost and the pursuer cannot proceed. If you're not time barred, you can start the process again and apply for signet once more. There are similar rules in the Sheriff Court, but there we talk about warranting and getting the warrant of the sheriff to serve the papers. Service of a summons can be carried out in a variety of ways. Usually it's served by registered post or personal service. For Court of Session cases, personal service is carried out by messenger at arms, who are akin to process servers or bailiffs in England and Wales. In the Sheriff Court, these officials are known as sheriff officers. In practice, messenger at arms are usually also sheriff officers.
If the defender is domiciled in Europe, then the period of notice given is 21 days. However, if they are domiciled further afield, then the period of notice is 42 days. Unlike in England and Wales, service by ordinary post is not effective.